Your organization may have spent millions securing its office buildings, servers, and internal networks. Yet, with a single click, vast amounts of sensitive data can be transferred to cloud environments located across multiple countries, managed by third-party providers, and governed by a complex web of regulations that many businesses barely even understand. Cloud computing has transformed the way organizations operate. It delivers speed, scalability, cost efficiency, and unprecedented flexibility. But beneath these advantages lies a critical question that every business leader, lawyer, compliance professional, and technology executive must confront. When your data moves to the cloud, does your legal responsibility move with it? Now, the answer is no. Regulators do not care where your data is stored. Customers do not excuse privacy violations because a cloud provider made a mistake. Courts do not accept ignorance of contractual obligations as a defense. As cloud adoption accelerates, the legal, regulatory, and contractual risks associated with cloud environments are becoming even more significant, more complex, and more expensive. The organizations that thrive in this digital era will not be those that simply embrace the cloud. They will be those that understand how to govern it, how to contract for it, and how to manage the risk that comes with it. Today, we will explore the regulatory, contractual, and data protection challenges that arise in cloud environments and examine the practical steps organizations can take to build compliant, resilient, and legally defensible cloud operations. Good afternoon, everyone, and welcome to today's webinar hosted by Adjun Legal on cloud computing and legal compliance, managing regulatory, contractual, and data risk in the cloud. My name is Elojo Joy, and I'm a legal intern at Adun Legal. At Adun Legal, we help businesses, startups, innovators, and technology-driven enterprises navigate the legal and regulatory complexities of the digital economy. Now, whether it is advising on technology transactions, data protection, intellectual property, corporate governance, or regulatory compliance, our goal is simple: to ensure that innovation is secure, compliant, and ethical. I'm excited to have you join us for what promises to be an engaging and insightful discussion on one of the most significant legal issues facing organizations in today's technology-driven world. Cloud computing has fundamentally transformed how businesses operate, enabling greater scalability, flexibility, collaboration, and innovation. Organizations are increasingly relying on cloud technologies to deliver services, store data, streamline operations, and accelerate digital transformation. However, while the cloud presents tremendous opportunities, it also introduces a new generation of legal, regulatory, and commercial risks. Questions surrounding data protection, cybersecurity, cross-border data transfers, contractual obligations, third-party risk management, and regulatory compliance have become central to organizational decision-making. Businesses are no longer asking whether to move to the cloud. They are asking how to do so responsibly, securely, and in compliance with the law. Today's session has been carefully designed to unpack these issues from both a legal and practical perspective. Now, we would explore how organizations can navigate the regulatory landscape governing cloud services, negotiate stronger contractual protections, manage data and cybersecurity risks, and build governance frameworks that support innovation while maintaining compliance. So whether you're a founder, business executive, legal practitioner, in-house counsel, compliance professional, technology leader, entrepreneur, or simply interested in understanding the legal realities of cloud computing, you're definitely in the right place. We are especially honored to have with us a speaker whose experience in corporate and technology law, regulatory compliance, and digital governance positions her perfectly to lead this important conversation. I'm confident that indeed today's discussion will leave us all with valuable insights and practical strategies for managing the legal realities of operating in the cloud. Now, without further ado, it is my pleasure to introduce our speaker for today's webinar, Barrister Norma Grace. I'll go ahead and read her profile right away. Norma is a corporate and tech lawyer, strategist, and the managing partner of Adun Legal. She specializes in corporate governance, intellectual property, and legal frameworks governing emerging technology. Her practice combines business law and tech, bridging complex technical operations with strategic corporate governance, with a deep focus on intellectual property, AI regulation, data management, and corporate practice. Her core expertise is in corporate and IP, founder protections, equity structuring and startup scaling, and tech law, AI governance, data privacy, and digital assets regulation. Thank you so much, Barrister Norma. We are indeed privileged to have you on this call with us today, and we genuinely look forward to every single thing that you have for us. Over to you, ma'am.
Thank you so very much, Joy, for that wonderful introduction. As Joy clearly stated, today we're going to be discussing cloud computing and everything that has to do with cloud computing and legal compliance. So how to manage your regulatory, contractual, and data risks in the cloud. Cloud computing is a major driver of modern business transformation. We all know this. Across industries, whether it's a startup, financial institution, a healthcare provider, or even the government agencies, these organizations all use cloud technologies to improve their efficiency, to cut infrastructure costs, to support remote work, and to speed up innovation, and even to scale rapidly. So the cloud is no longer just a technological choice. It is a core piece of digital transformation and a core piece of the operational efficiency within your organization. However, moving critical systems, applications, and data to the cloud reveals a clear reality. Cloud adoption is also a legal, a regulatory, and a governance challenge, not just a tech project. And how many organizations truly understand the legal impact of moving to the cloud? This is the big question for which we're going to answer today. And today we will explore the regulatory landscape, data protection, privacy, cybersecurity expectations, contracts, vendor management, incident response, and emerging tech risks, all within the cloud computing environment. Crucially, we will also share practical strategies to manage these hurdles while still capturing cloud benefits. Because the goal of this webinar, the goal of this masterclass today is not just to understand cloud risks, it's also to learn how compliance, governance, and risk management can turn a potential exposure into a powerful driver of innovation, resilience, and long-term success. Are you guys excited? Because I am. So let's dive right in. First, we need to understand cloud computing, especially from a business and from a legal perspective. If you've checked your mail, if you even stored a file online, if you attended a virtual meeting as we're doing today, if you backed up your photographs, or if you even used a shared workspace, you have in one way or the other interacted with the cloud. Many people and many businesses rely on these services daily without thinking about the underlying infrastructure. And I wouldn't blame you. It's pretty easy to pick up your phone and send a mail, or to pick up your phone, take a photograph, and have that photograph be stored on the cloud. But at its core, cloud computing means delivering computing resources over the internet. Instead of buying and maintaining physical servers on premise, organizations can access these computing power, storage, software, databases, and even networking from specialized providers. Businesses consume this technology as a service rather than owning and managing it, which is what makes it so easy for each and every one of us to use. But this shift has fundamentally changed operations. Previously, to expand your digital capability as a business required heavy upfront investment in hardware, data centers, and even maintenance staff. But today, these resources deploy within minutes via the cloud, allowing businesses to scale quickly, cut costs or to cut capital expenses, improve global collaboration, and speed up innovation. However, changing how technology is delivered does not eliminate legal responsibility. when an organization moves data, it moves its applications or even processes to the cloud, it delegates its operational functions, yes, but it does not delegate accountability. So the legal obligations that are attached to that data and activity remain firmly with you, the organization. But to understand this clearly and practically, we must take a very we must look at the different forms that cloud services take, or the different models of cloud services. The first we have is infrastructure as a service. Now, this is where the provider supplies the fundamental infrastructure like servers, storage, and networking, while the customer manages operating systems, applications, and data. It's like renting the building blocks of an IT environment while controlling exactly what is built on top. Then we have platform as a service. This is where the provider delivers the infrastructure plus the underlying platform needed to develop, to test, and to deploy applications. This lets your organization focus on creating the software without maintaining the technological framework behind that software. And the third cloud computing model, which is also the most popular one, is software as a service, SaaS. It is where complete software applications are delivered over the internet. So users simply access the service while the provider manages the infrastructure, the platform updates, and securities, and generally everything else that has to do with the service. Now, this distinction matters legally because the allocation of responsibilities changes with each model. The risks of managing your own applications on rented infrastructure differ from using a fully managed software program. Knowing who controls what is essential for assessing your liability, for assessing your regulatory obligations, even the cybersecurity needs or the cybersecurity features you would have to put in place, and the contract that you need to put in place to protect yourself. Now, other than the cloud computing models, there are also several deployment models of these cloud computing services. And with each deployment model comes its own legal complexity. Now, you can choose as an organization, you have the privilege of choosing how to structure your cloud environment. The first deployment model is the public cloud. Now, this is where your computing resources are shared amongst multiple customers. So everybody has access to the same cloud infrastructure. The second is a private cloud where the resources are dedicated to a single organization. The third is a hybrid cloud where it's a combination of both computing resources shared among multiple partners and you or all these resources being dedicated to a single organization. So a combination of the public and private approaches. Now we also have the multi-cloud strategies, which uses several cloud providers simultaneously. As these environments grow more sophisticated because development and innovation takes place daily, the legal questions become more complex. Questions like where is the data physically stored? Which country's laws actually apply? Who can access the information? Who is responsible for a security incident? And so many more questions. Now, your technology teams cannot answer these questions alone because they require legal, they require compliance, they require governance, and even risk professionals to answer them, or at least to give their insights on them from the very beginning. And so ultimately, cloud computing is a governance and risk management and even legal strategy, not just a tech or an operational strategy. Every cloud decision that you make has legal consequences, from selecting your provider, your cloud provider, to negotiating your contracts or even just signing one like that, to transferring data across borders, to setting up cybersecurity controls, or to even responding to data breaches. Now, the most successful organizations, as Joy rightly pointed out, they do not just move to the cloud. No, they understand the legal implications and they build governance structures to manage their services or to manage their benefits within the cloud. Because the cloud, it changes where technology resides, but it does not change who remains accessible or who remains accountable. Now that we've discussed all this, what exactly is the regulatory landscape that governs these cloud operations? At first glance, you can think that, oh, cloud computing is borderless, right? Because it's everywhere. Because Data can be stored in one country, it can be processed in another, it can be accessed from multiple locations simultaneously, and it can be managed by a provider headquartered elsewhere. This flexibility is a business strength, true, but it also introduces immense regulatory complexity, because when an organization uploads its customer information to a cloud platform, which country's laws apply? Is it where the company operates, or is it where the provider is located, or is it where the data sits, or is it where the customer resides? You see, the reality though is that it could be all of the above. Multiple legal regimes can apply to the same data set simultaneously. And so organizations can no longer view compliance through a purely domestic lens. The cloud has turned compliance into a global issue, even for local or regional businesses. And this shift coincides with an unprecedented rise in regulatory focus on data governance, cybersecurity, privacy, and digital resilience. Because data is one of the most valuable assets in the digital economy, and governments worldwide are imposing stricter obligations on how data is collected, how it is processed, how it is stored, or even how it is transferred in the cloud. Importantly, regulators do not care whether your own servers rely on a third party provider. Their focus remains entirely on accountability. And so, if your company handles personal information, financial records, health data, or any sensitive customer data, really, or even any essential digital service, you remain responsible for legal compliance. And assuming that regulatory compliance will automatically follow because a cloud provider is reputable, it creates dangerous blind spots for you. Because while the providers might supply technology solutions, compliance obligations cannot be outsourced. Now, what is the industry scrutiny for all of these for this entire regulatory landscape? The first is that financial services, which are like banks, insurance companies, payment providers, and investment firms, they all face extensive oversight. When migrating critical functions to the cloud, regulators still expect effective governance, risk management, operational resilience, customer protection. So even though you have a cloud provider that, in quote, handles all these things, or in quotes, a cloud provider to whom you have, according to you anyways, outsource this information to, you are still responsible for these things in the eyes of the government and in the eyes of your customers. The same is applicable for healthcare industries, and the same is applicable across as many industries as they are, whether that's e-commerce or even general tech companies. And so, as organizations navigate this space, a trend of regulatory convergence is emerging, because while jurisdictions have different frameworks, modern regulations globally emphasize the same core themes, which is data protection, transparency, accountability, cybersecurity governance, risk assessments, incident reporting, and third-party oversight. Compliance is not a one-time box-ticking exercise. It is an ongoing process that must evolve alongside your technology and alongside the law. Furthermore, regulators have, they have expanded their focus from just data protection to even operational resilience. So cloud outages, cyber attacks, infrastructure failures, and vendor interruptions can disrupt millions of users instantly. And so consequently, regulators expect that organizations have to assess your risks and develop contingency plans and also maintain business continuity, so that regardless of any of these risks, whether it's a cyber attack, an infrastructure failure, a cloud outage, you are still able to continue operations. And so this leads to an unavoidable question, which is, what exactly are an organization's responsibilities when personal data is involved? And so to answer that, we must take a look at data protection and privacy compliance in cloud environments. Now, let's imagine that a company collects data through its website and stores it on a globally recognized cloud platform. Months later, a privacy violation occurs, thus exposing customer data. Regulatory authorities investigate, and affected individuals demand answers. Who bears the responsibility for this? Many organizations instinctively point to the cloud provider because they host the infrastructure and they manage the servers. Yet, legally, that answer is rarely sufficient, if ever. A fundamental principle of data protection law is that accountability follows the organization that determines why and how personal data is processed. And so, whether or not you transfer data to the cloud, it does not transfer your responsibility. You, as the organization, remains accountable for handling your information lawfully, for handling your information securely and transparently. And so, if or while some other businesses might view cloud migration primarily as a technology project, regulators view it as a data governance issue. The moment personal information enters a cloud environment, legal obligation rises across the entire data lifecycle. For, just in case you're not aware, personal data refers to any information that can directly or indirectly identify an individual. So, such as your name, your email address, your phone number, your identification number, your financial information, location data, online identifiers, employee records, customer profiles, etc. Any information that can directly or indirectly identify an information is categorized as a personal data or personal information. And data protection laws exist to protect individuals from the misuse of this information, ensuring that organizations handle data responsibly. Now, these are some of the foundational principles of data protection, which is, we know them already: lawfulness. The data you're collecting must have a lawful basis for collecting it. You must be transparent with what you do with the data, why you collected it in the first place, how you will process it, who receives it, and all of that important information. Also, purpose limitation. All right, the data you collected must be fit for purpose only. You can't collect data that you don't need, or data that you think you will repurpose into something else. No, the data that you collected must be used for the purpose for which you collected it, and that purpose only. Data minimization. Again, you must collect only the data that you need. Security. You must implement appropriate technical and organizational safeguards to take good care of the data that you have collected. Now, there are other individual rights and operational realities within data protection, even as a law, because each jurisdiction's laws grants the individuals that those laws are applicable to specific rights, right? They can access their personal information whenever they want. They can request for corrections. They can object to the processing of their data, and many rights that have been granted to them. And so, rather than treating privacy as an afterthought, privacy by design requires that individuals and even organizations build these considerations, whether it's the individual rights or even the foundational principles of data protection, that these be built into your system, your product, or your processes from the very beginning. And when any organization follows a proactive approach, privacy risks are evaluated before deployment and migration, thus allowing controls to be built in and risks to be managed early on. Conversely, of course, if you follow a reactive approach where your privacy risk is only addressed after deployment, you find out that at that stage you'll be scrambling to fix vulnerabilities, or you might even have to redesign some of your processes or even a feature in your product, or maybe you might have to renegotiate contracts or answer regulatory inquiries. So ultimately, data protection in the cloud does not restrict innovation. That is a truth that we have established. It ensures that data protection happens responsibly. And as an organization, it is your responsibility to include privacy in the build and in the design of your product, of your system, and of your processes from the start. That proactivity will save you a lot. And now, what happens when obviously you have built all these things into your product, your systems, your infrastructure from the very beginning, but still your data is still moving across border? Once we discuss cloud infrastructure, once the conversation of cloud infrastructure comes up, an important reality is that data rarely stays in one place. When your organization uploads information to the cloud, do you know where that data actually goes? I can bet not many of us do, or not many people do know exactly where that data goes and exactly where it's going to be stored in. Many business leaders assume that if their company operates in one country, their data stays there. Yet cloud computing distributes data across multiple data centers, across multiple servers, across a wide range of geographical regions to improve the efficiency, reliability, and availability of those servers and of those systems that help your cloud computing models work the way that they are meant to work. And so as a result, information uploaded from, say, Lagos State today could be processed through infrastructure in Europe. It could be backed up in North America at the same time, replicated in Asia, and accessed by authorized personnel from many places all at the same time. So technologically, this is very, very impressive, right? But legally, as you can imagine, it creates a complex compliance web, or even it makes compliance more challenging. And so you can understand that an organization might choose a cloud provider with overseas infrastructure, or the provider might automatically route data between regional centers as part of its operational architecture. The issue here is that not every jurisdiction provides the same level of privacy protection. If a country has strong privacy laws, regulators want to ensure individuals do not lose these protections simply because their information moves elsewhere. Consequently, many frameworks restrict international transfers and require organizations to implement safeguards before moving data across borders. So you see, compliance is no longer just about the data that is collected or how it is collected and secured. It is about where the data travels to and the regulations in place in that particular place that it has traveled to. And so as an organization, the key question you should ask yourself before you use any cloud service provider is, does this international transfer or international data transfer comply with the applicable data protection requirements? Now, earlier we spoke about the foundational principles of data protection, and those foundational principles are the same across board. So it's an easy way for you to know whether the international transfer policies or the international user or the international cloud service provider that you're contemplating, that their policies align with the applicable data protection requirements. Legal requirements also mandate that certain categories of data must be stored, processed, or maintained within a specific jurisdiction. Governments introduce these rules for national security, critical infrastructure protection, regulatory oversight, economic policy, or even to control sensitive information. For companies operating in multiple markets, data localization creates considerable operational complexity because one jurisdiction may permit unrestricted international transfers, while another may require specific safeguards before data leaves its territory, and yet another may completely prohibit certain categories of information from being stored abroad. So as an organization, you must design your cloud strategies to satisfy multiple regulatory expectations simultaneously. This makes cloud governance critical to your operations because your data location cannot be treated as a purely technical issue left entirely to IT teams or to your tech teams. Legal, compliance, privacy, cybersecurity, procurement, and even business stakeholders must work together to track your data flow and their attached legal obligations. Because as any business, they can ask you, says, can you confidently identify where your data resides at any given moment in time? The answer to that might be no. And you won't be the only one because many businesses also struggle to answer this very question. They know their cloud provider, but they lack visibility into actual storage locations, backup arrangements, if any, disaster recovery sites, subcontractor involvement, and transfer mechanism. This lack of visibility can also create massive compliance risks for you. So to address these risks, organizations should conduct a data mapping exercise before migrating to the cloud. This includes asking yourself, what information exactly is being processed? Where does that information originate from? Where does that information travel to? Who can access it? Which jurisdictions are involved during the life cycle of that information? Mapping this data this way allows your organization or your startup to catch high-risk transfers at the start and implement safeguards proactively, which is significantly easier to do than responding to regulators or dealing with disgruntled users, or even having a problem after it has emerged. Contractual protections are also important because cloud service agreements should clearly address data storage locations, transfer mechanisms, subcontractor involvement, and regulatory cooperation. Organizations must know if providers reserve the right to move data and what safeguards apply. Contractual clarity reduces uncertainty and it strengthens compliance. Beyond legal duties, there is also a trust dimension. Customers, business partners, and regulators all demand transparency regarding international data flows. And so, when you manage these expectations, it also helps to maintain stakeholder confidence, especially in a digital and interconnected economy as what we live in now. But ultimately, cross-border transfers are both a major advantage of cloud computing and one of its greatest legal hurdles that we will continue to solve as the technology and even as our legal systems in all of our jurisdictions continually evolve. But regardless of where data resides or how it moves, one question remains constant. How secure is that information through all these many places and jurisdictions it might move through? How secure is it? Because that question sits at the heart of cloud governance. Cybersecurity is no longer just an IT concern. It is a legal, a compliance, a business continuity, and a boardroom issue. Data's high value makes it a primary target for cyber criminals. Customer information, financial records, trade secrets, intellectual property, employee data, and confidential business information communication, they all hold significant economic value. And as organizations migrate these assets to the cloud, cyber threats inevitably follow. However, cloud computing itself is not inherently insecure because leading cloud service providers invest billions of dollars in security infrastructure, in monitoring, in threat intelligence, and even in expert personnel to handle all of these. So the challenge is not that cloud environments are weak by design. No, the challenge is that organizations or startups frequently misunderstand their security responsibilities within them. And so if a company stores sensitive customer data on a highly secure cloud platform but grants excessive access privileges to employees, then who then created the risk? Because the technology might be secure, yes, but your practices are not. And so cybersecurity is not just about infrastructure strength. It is also about people. It's also about processes. It's also about policies. And it's also about technology. All of these factors all work together to make sure that your cybersecurity and your information is secure. But from a regulatory standpoint, cybersecurity obligations have expanded significantly. Now, regulators worldwide recognize that data protection cannot exist without effective security controls, and they expect organizations to prevent, detect, respond to, and even recover from cyber incidents. And so you find that as an organization, there are several core components that you need to have as regards cybersecurity governance. The first, obviously, is risk assessment. Before you invest in any security, your organization must understand their specific risk. Then you have to manage your access to, you have to manage access or the people that you grant access to that system that you have. Because when individuals or when many more individuals gain access to systems that they should not have, that's when problems arise. Encryption is another core component of your cybersecurity governance. You need to, when you encrypt your information, is basically when you encrypt your information, literally, is when you protect it from adversaries. You also need to continually monitor your information. So encryption alone is not enough. You cannot protect what you cannot see. So when you continuously monitor these organizations to identify suspicious activity, detect anomalies, and even respond before any minor incidents escalate. Now, which leads us to incident response plan. Again, incidents are bound to occur. But when they do occur, you need to have a way to respond to them. And your incident response plan establishes these procedures beforehand. It defines your responsibilities, communication channels, escalation processes, investigation protocols, and recovery measures to turn a chaotic situation into a structured process. And so this preparation is very important because cybersecurity incidents carry severe legal and financial consequences. So yes, cybersecurity in the cloud is not about achieving unrealistic perfect security. It is about proving that your organization understands its risks, you implement appropriate safeguards, and you maintain effective oversight and can respond decisively when things go wrong. Now, after you've known all this, how exactly can you allocate responsibility and manage contractual risks in a cloud relationship, aka a relationship between you, the organization, or the user, and your cloud service provider? The question you need to ask is, first of all, who is actually responsible for ensuring compliance in a cloud environment? If an organization stores sensitive customer information in the cloud and a compliance failure occurs, who should regulators hold accountable? The provider, the customer, you, or all of you? The answer to these questions depends on the circumstances of the case, yes, but one principle remains consistent. Responsibility is shared across these parties. It is not transferred from one person to the other. It is shared. And this is the shared responsibility model that recognizes that both the cloud providers and the cloud customers have distinct obligations. The provider secures specific aspects of the infrastructure, yes, but the customer remains responsible for data, for user access, for regulatory compliance, and for internal governance within their own organization. And so cloud computing operates exactly like that. So while the provider might secure these physical facilities, might secure networking, hardware, and other core services, the customer remains responsible for how it uses those services, for how it manages its data, grants access, configures security settings, and meets legal obligations. Most cloud compliance failures happen because you, as the organization, you misunderstand your own responsibilities, and you think that the service provider will offer more than they're actually meant to offer. Because while the providers might offer sophisticated security tools, and yet you as the organization fails to activate them, or you misconfigure the environment, or you grant excessive privileges to people who are not meant to have it, or you neglect monitoring, the risk remains with you. And while the provider might offer capabilities of their cloud infrastructure, they cannot make governance decisions for you as the customer or as the user. And so what role does cloud contract or does cloud computing contracts play in this? Just like any other contract, a cloud computing contract is a vital risk management tool. It's not just a document to procure cloud services. No, it's for you to manage your liabilities and manage or mitigate any risks that you will likely have. It determines how your responsibilities are distributed, how disputes are resolved, what remedies exist, and how compliance is supported throughout the relationship. Many organizations focus heavily on technical specifications like storage capacity, system performance, scalability, pricing, and they fail to scrutinize the legal terms contained in the contracts that they quickly just click I agree to, or they quickly sign without going through them. And when you enter these cloud arrangements without understanding data breach liabilities or outage protocols or even audit rights, data return procedures, or liability limits, this can lead to a very, very costly mistake that no organization, especially not ones at the start, wants to make. And so some of the things that you need to look out for in any cloud computing contract is the service commitment. Contracts must clearly define the expected service levels, the system availability commitments, maintenance schedules, support standards, response time, etc. What commitments are you getting from your cloud service provider? What are the security obligations? What about the compliance support? If a regulator requests information about data processing within a cloud environment, the contract should guarantee that the provider will cooperate and make necessary records available. Do you have that in your cloud computing contract? What are the liability allocations like? If a system fails or a breach happened and regulatory investigations or business disruptions occur, is your contract ironclad enough to protect you from certain liabilities, or are you left open? And then there are also the exit and transition strategies. So let's say, what happens to your data when you decide to leave or migrate from a cloud service provider to another one, right? What about your business needs or your vendors or even your strategic priorities that may change over time? How can you easily and carefully migrate or transition or even exit that particular cloud service provider? These are all questions that you need to ask, and these are all questions that a cloud computing contract should answer for you. Now, how to choose or select the right cloud service provider and how do you negotiate your contractual safeguards? Like we promised earlier, we're also going to give you practical strategies of how to select your cloud service provider and to negotiate your contractual safeguards. So we're not just leaving you with all the things that can possibly go wrong. Essentially, choosing a cloud service provider is an exercise in trust, because when you're moving sensitive information to the cloud, you rely on the provider to maintain security, to support compliance, to ensure operational resilience, and to protect critical functions. That trust must be based on evidence rather than assumptions. Effective vendor due diligence requires a deep look into the provider. Who is the provider and what exactly is their industry reputation? How mature are its governance structures? Does it have a demonstrated commitment to cybersecurity and compliance? Has it experienced significant security incidents or regulatory enforcement in the past? These are all the questions that you must ask. And you, as the organization, you remain accountable for protecting your data, even when it is stored by a third party, thus making your provider security capabilities a compliance necessity. So this is not something that you can miss out on or something that you can compromise on. And so instead of relying on marketing claims made online, you need to seek concrete evidence of effective controls through, number one, this cloud service provider, do they have the requisite security certifications and independent audit reports? Have there been several compliance assessments and governance frameworks that they have duly followed? What are their penetration testing programs like? These are all questions that you need to ask. Now, as for negotiating your contractual safeguards, you must not assume that a provider's standard terms are acceptable simply because they are a large and established enterprise. Contracts are risk allocation instruments that determines what happens when things go wrong. A carefully negotiated agreement reduces uncertainty and it strengthens compliance. Well, as you can guess it, a poor one will expose your business to unnecessary legal and operational financial risks. And so the contractual areas that you should pay attention to is data ownership and confidentiality, as we rightly said earlier on. What are the specific security commitments that you as the organization or as a startup, what are the commitments that you're getting? What audit rights do you have? What is the subcontractor management like? Because sometimes cloud providers can rely on a network of third parties to either host, store, maintain, or support your data. And so you must be aware of who these subcontractors are. If not in detail, but at the very least, if asked about it, you can confidently answer. And then again, what is your exit plan? Because every cloud relationship eventually ends either due to business growth, a merger, a strategic change, or even a regulatory update. And so as a user, you need to be aware of exactly what it is that you are getting yourself into. In conclusion, guys, I know that this has been a lot because we've gone through so many different things now, and we will be here to answer as many questions as you might possibly have. But in conclusion, as you have clearly seen or gleaned from this, cloud computing is not simply a technological or operational solution. It is imperative to the success of your business. It is also a governance challenge because, again, data moves to as many places at the same time and is handled by many more people at the same time. So it is not only is it a governance challenge, it is also a legal responsibility that each stakeholder involved in both the cloud service provider, you as the organization, and your users and even the regulators, because they are also a stakeholder in your business. These are things that you need to take care with, because while the cloud offers immense opportunities to innovate, to scale, to even to collaborate with many more people, moving your information there or migrating to it does not transfer accountability. Instead, you can share the accountability and the responsibility, but it does not transfer it, because your regulators, the customers, and all your other business stakeholders still expect you as the startup, as the organization, to protect their information and to maintain compliance regardless of where your data resides or where it moves to. And so navigating this complex landscape requires a coordinated approach that unites legal, compliance, technology, business, cybersecurity, risk management, and every other important function to continuously assess these risks and implement safeguards. Ultimately, the choice comes down to whether or not your organization treats cloud compliance as a regulatory burden or as a strategic advantage. As we said earlier, you must be proactive, because the most resilient organizations recognize that innovation and accountability must move together at the same time. And so when you embed these strong governance protocols or practices into your digital transformation from the very beginning, it helps you, because it transforms compliance from a source of exposure into a foundation of trust, of stability, and of sustainable long-term growth that your customers, the regulators, and other business stakeholders really would be proud to be associated with. And that brings us to the end, guys, of this masterclass. Joy, over to you. Thank you very much.
Noma, I thank you so much, Noma. I vehemently believe I speak for myself and every single person that joined this live webinar, as well as every single person that would stream it afterwards on our YouTube channel, that we have indeed gained a lot. Thank you so much once again. Thank you so much once again, ma'am. It has truly been knowledge packed having you take us on this session today. Now let's go over what we have learned so far, shall we? The cloud indeed offers a whole lot of opportunities. It enables organizations to innovate more quickly, scale more efficiently, improve collaboration, and access advanced technologies that were once available only to the large enterprises. Now, these benefits explain why exactly cloud adoption continues to accelerate across industries and jurisdictions. However, with these opportunities come significant responsibilities. Organizations must navigate an increasingly complex landscape of regulatory requirements, data protection obligations, cybersecurity expectations, contractual commitments, third-party risk, and emerging technology challenges. The reality is that moving to the cloud does not transfer accountability. Regulators, customers, business partners, and stakeholders continue to expect organizations to protect information, manage risk, and maintain compliance regardless of where their data resides. Now, throughout this webinar, we have seen that effective cloud compliance is not achieved through a single policy, a single contract, or a single security control. It requires a coordinated approach that brings together legal, compliance, technology, cybersecurity, risk management, and business functions. It requires organizations to understand their obligations, assess their risk, implement appropriate safeguards, and continuously adapt to an evolving digital environment. Now, let me leave you with one final question. Is your organization treating cloud compliance as a regulatory obligation, or is it treating it as a strategic advantage? The answer to that question may determine how successfully your organization navigates the future of digital transformation. Indeed, the most resilient organizations are not necessarily those with the largest budget or the most sophisticated technologies. No, they are the organizations that understand that innovation and accountability must move together hand in hand. They recognize that trust is a competitive asset, governance is a business enabler, and compliance is a foundation for sustainable growth. Having dealt with cloud computing and legal compliance this month, next month we will explore blockchain and cryptocurrency technology legal, regulatory, and commercial realities for modern businesses. And we will have our speaker dissect this theme bit by bit in our next month's webinar. As usual, this is one you really do not want to miss, I promise you. Clear your calendar, remain glued to our LinkedIn page for more information, and ultimately join in on the conversation. Thank you once again to our speaker and host, and to everyone who joined us today. We are certain that you really gained value. We look forward to having you again next month.
Thank you.